Recent victories, won by trial lawyer Roger McCleary of Beirne Maynard Parsons in Houston, Texas, include catching the game-winning touchdown in Super Bowl 49, the successful defense of an insurer against a $50 million fraud claim, and recovery of over $10 million for a construction contractor against a non-paying owner claiming construction defects. Roger has been named a Texas super lawyer and is a member of the American Board of Trial Advocates. Today we ask, is all business good business? Learn how your company's salespersons, business managers, and contract attorneys could be unwittingly planting stealth time bombs, exposing your company to litigation, and giving potential adversaries ammunition capable of impacting your company's financial condition. Please join me in welcoming Roger McCleary.
Thank you very much, Luke. Good morning, everyone. It's wonderful to be with you here in Napa Valley, California. What an incredible place. Yesterday I was out playing golf with a number of you. I think we can call it golf. And I had the opportunity to meet Johnny Miller, the famous Hall of Fame golfer and noted broadcaster on golf events, right off the 13th hole. And that was really, really cool. And it's true, I literally did meet him yesterday. He apparently had seen my approach shot to the green on the 13th hole, and then he asked me for some tips afterwards. Okay, well, that part is not true, but one can always dream. Anyway, it's a beautiful place out here in California. Although it is so incredible out here, I don't plan to move out here or retire out here from where I live in Texas. There are just too many differences. For example, I've learned out here in California that everyone knows how to eat an artichoke. We don't know how to do that out in Texas. In fact, when I was growing up, artichoke was something that you did to a guy named Artie that you don't like. A lot of differences. Apparently the four seasons out here are fire, flood, mud, and drought. Whereas where I grew up in Texas, you learn that you can eat barbecue beef 7 days a week. It's perfect. You also can learn to like both types of music, country and western. And on top of that, we pronounce oil well the same as all well. And then finally, we think that voir dire is a type of wild game that you can shoot. So speaking of shooting, I'm going to be talking this morning about commercial time bombs. And these are the kinds of things that, as general counsel, will and can keep you up at night, maybe even more likely assistant general counsel. But they definitely need attention. And I'm going to talk first about a case in which we had several of these time bombs all in one matter. I'm going to focus on this one case at first. I'm going to be intentionally obtuse about some of the facts and circumstances to protect my client, but everything else that I tell you is going to be substantially true. I received a call to pursue a $10 million plus hard dollar claim for unpaid work on a cost-plus project on which my client had already been paid $100 million plus. And I'm sorry, I don't know why we have that overlay there, but in any event, that's not in the materials. But it's very important that you remember in context that they had already been paid, my client had already been paid over $100 million on this project. The owner, there were some problems with the project because under the contract, the term of the contract had already expired, and it was at the end of the contract term. My client had not been paid millions of dollars, and so my client had demobilized before the project was complete. The bad actor in the case, and that was literally the owner's name, we called him bad actor, had asserted bogus claims of over $15 million stemming from allegations of defective work and schedule delays and overruns. And this was so even though the owner had been very derelict and delinquent in providing us with the necessary specs to complete the job. They'd required many, many changes, and they wouldn't sign the change orders. And they had approved all the punch list items on the project before my client had demobilized. Where was the project state? I'm not going to tell you, but it is a state that had an affinity for a green leafy hallucinogen. that will help you narrow it down a little bit. We had this major problem with the contract, and this was the first major time bomb, of course. There was no penalty provision, nothing in the contract that disincented the owner of the project not to string along my client, which is exactly what they did. The contract did not provide for an award of attorney's fees or penalties of any kind for non-payment. Another time bomb in the contract was the fact that the choice of law provisions provided that the law that applied to the contract was the law of the bad actor, the owner's home state. That home state, you want to know what it is? I'm not going to tell you, but it's another state that had an affinity for green leafy hallucinogens. The law of that state was not helpful because it didn't even provide for an award of attorney's fees in the event you won a breach of contract claim unless attorney's fees were provided for in the contract, which they were not in this instance. The agreement provided for non-binding mediation, ADR, that proved to be a failure in this instance, and 30 days later under the contract, we would have been able to file a lawsuit in federal court. The only leverage my client had to assert against the bad actor owner on the project was the assertion of a Prompt Payment Act provision from the forum state where the project was that provided for an award of, or a penalty of 2% per month on past due amounts for retention and progress payments. But that led to a catch-22, as you'll see. Did we have a positive outcome in the case? Of course, absolutely. In all honesty, I probably wouldn't be focusing on this case had we not. But the catch-22 arose because the choice of law provisions from the forum state where the lawsuit would have had to been filed provided that you would apply the law of the forum state unless it was contrary to the fundamental policy of a state which had a materially greater interest than the chosen state. It seemed great. So clearly the law of the state where the project existed, where my client hadn't been paid, would have a materially greater interest, and we could apply the prompt payment penalty statute. Here's where the catch-22 arose. As we were preparing to file the lawsuit and doing our due diligence, conducting our investigation, we determined that our client had not obtained a general engineering contractor license, even though they were doing general engineering contractor work, and had not obtained a general building contractor license. They had obtained some specialty licenses, but those were not adequate. And the upshot here is that under the very draconian licensing laws of the forum state where the project was, there were two huge consequences. First of all, the law provided that you could not pursue your claim, our claim, for the $10 million plus in hard damages that we had not been paid. Gee, that's not good. But then it got worse. It also provided that the owner had the right to pursue a claim for disgorgement of all the compensation that had been paid on the project. So we're talking again about a project in which my client had already been paid over $100 million. There was nothing you could do. Obviously, we looked and dug deep. Nothing you could do to fix this problem. You couldn't go get licensed in the forum state and have it apply retroactively. There wasn't any wiggle room. You couldn't argue substantial compliance unless you had previously been properly licensed on the job, which my client had not. And we didn't have a good argument that the unlicensed work was incidental and supplemental to the licensed work. So when I met with my client and explained all this to my client and explained to him that not only did we have, or were we faced with a difficult defense to our claim for the $10 million hard dollar claim, but also they were faced with potentially having to pay back much, if not all, of over $100 million that had been paid on the project. This was his reaction, which we got on security videotape. I was given a partial waiver of the attorney-client privilege to use that clip. And what you don't see on that clip is that before this came up, my client was a lion. And when he heard the word disgorgement, magically turned into a lamb, a little sheep. So what was the result? What did we do about this devastating issue? We engaged in some very strategic settlement negotiations with the owner, and we did cut a deal with them that provided for actually recovery of over $10 million of the hard dollar claim. There was no offset for the $15 million counterclaim asserted by the owner with respect to all these claims of abandonment and overruns. Didn't have to disgorge the over $100 million my client had been paid. But the real consequence of this, of these time bombs in the contracts, in this instance were that my client had to walk away from a prompt payment penalty claim that potentially added millions of dollars to the value of the claim. There was no interest and no attorney's fees. A great result, but it could have been certainly much better had we not had these commercial time bombs in the contract. The lessons, you want to really check and watch your tail when you're negotiating and drafting these contracts, when your business people are out doing that, your engineers, your salespersons, all of them, you want to look at your contract and consider what kind of a tail do you have after the job's over with that might end up making that contract not only less valuable, but maybe more costly than profitable. You want to make sure that you have disincentives in the contract against non-performance and non-payment. You want to make sure it's not entirely one-sided. I know that can be difficult. Obviously, it's difficult economic times, but you got to consider the consequences when you enter into a one-sided deal and you're not on the right side of those issues. Certainly, you want to have in the contract the opportunity to recover interest and attorney's fees as to both undisputed amounts that you're owed and disputed amounts that you win and are entitled to recover. Also, another oversight is not looking at whether the guarantees and the warranties and the limitations and all the conditions in the contract, conditions proceeding to recovery, whether all these work together and are harmonious and they make sense. Because ultimately, if it goes south, I'm going to have to explain it to a judge and jury in a way that they understand. And when you have a contract, which in this instance was kind of a cut and paste contract from a variety of different projects, it was not harmonious. And I had to work very hard and did to harmonize these provisions and make arguments that would make it harmonious if we did end up filing a lawsuit. But you want to consider that on a go-forward basis, even as to your old deals and contracts, because circumstances develop where they're just no longer harmonious, and you want to correct that on future contracts. On choice of law, do your due diligence. You want to assess truly what the practical effect of the choice of law provision and what law will apply to the deal happens to be. You want to determine whether there is a duty of good faith and fair dealing that will apply to the contract under the law of the choice that you make. You also want to make sure all your key contract provisions are enforceable, including as to indemnities, see what the law is on punitive damages. Do they award attorney's fees in the event of a breach, maybe on notice, or do you have to have that in the contract? On forum selection, consider whether you want to maybe even have a neutral forum, whether the forum of the other party or your own forum. So the problem that I've seen in a number of instances is we all have a natural tendency maybe to become a little colorblinded by the fact of our involvement in the negotiations or with the company. And there are a couple of examples of this that I've seen in particular. It's where the client and their business people, they all know what the deal is. They know what they intended. They know what the handshake deal was with the other side. So they think they know what's in the agreement, but in fact, what they think is there, or certainly what the term of the deal is absolutely missing from the contract entirely. And an example of this is a matter I was involved in on a $50 million cogen project where the entire project, all the economics, the performance obligations and responsibilities, everything depended on the volume and quality of the BTUs of blast furnace gas being provided to the cogen facility, and that wasn't even mentioned and established under the four corners of the terms of the contract. A complete oversight time bomb. And another example of this would be in the context of ambiguities, where you know something is there, there's something in the contract, but it's not really clear exactly what it is or what it's going to mean. And so I think it's very helpful for you to understand also the practical realities of these ambiguity problems in contracts. And what do I mean by ambiguities? Okay, this is not what I mean by ambiguity. If this guy looks a little familiar to you, this is our good friend Joe Krasovic, who was our last speaker. And I should add that Joe actually did not pose for me to use this picture in my presentation today. This is a photo that was taken on his honeymoon in Bermuda by his beautiful wife. And in a great bit of advocacy, I was able to talk her into sending it to me. That's a classic example of a time bomb. So, what do I mean by ambiguity? What am I talking about? We all know generally ambiguity involves contract provision where you have uncertain and doubtful meaning, or a language that's reasonably susceptible to more than one meaning. Ambiguity is a question of law for the court, and if a contract is ambiguous, then you have an interpretation issue, a question of fact for the jury, and the practical result here is you have lost control over your deal, you've lost control over the terms, how it's going to be interpreted and applied, and it's going to be up to a judge and a jury. And that can be a real scary thing. In fact, the real problem is, and I want you to understand how complicated this can be, is that it's very unclear what evidence will come in to the judge on the issue of ambiguity, or maybe even to the jury. And this example is under Texas law, but the laws of most other states are relatively similar to Texas law. So you'll see this is just clear as mud, because under the parole evidence rule, which of course addresses oral evidence and documentary evidence outside the four corners of your contract, parole evidence is usually not admissible to contradict or vary the meaning of explicit language of the contract prior to the finding of ambiguity in the contract. But on the other hand, to determine if the contract is ambiguous, courts may examine extrinsic evidence to interpret the contractual terms and extrinsic evidence of the circumstances surrounding execution of the contract. But on the other hand, parole evidence is barred if it contradicts, varies, or adds to the terms of an unambiguous written agreement. Yet, it's admissible to give the words of the contract a meaning consistent with that to which they are reasonably susceptible. In other words, again, to interpret when it's not admissible to interpret. Plus, parole evidence which tends to explain the written instrument on an obscure point but does not contradict or alter the written instrument is admissible. Then again, we also have two types of ambiguity, patent or latent. Patent's evidence on the face of the contract. Latent arises in context based on some collateral matter. Extrinsic evidence is admissible if we have a latent ambiguity. And then parole evidence the rule precludes enforcement of a prior or contemporaneous inconsistent agreement, but not consistent or a subsequent agreement. Also, a court will consider the surrounding circumstances in determining whether an agreement is an integrated agreement. And then finally, of course, if you have an agreement that's ambiguous, the parole evidence rule does not apply. So is everybody clear on all that? It is a lawyer's dream. And you can imagine dealing with these issues with the judge or with the jury, as the case may be, you really don't want to go there. So what happens if you have an ambiguous agreement? You have a fact issue. It's time for a jury. What does that mean to some of our clients? You're going to have a jury, some jurors deciding the intent behind your contract and your terms. And I'm not going to go through all these, but who are the jurors who might be considering this? A recent study of some college graduates found that they thought Christ was born a long time ago, as far back as the 17th century, that Charles Darwin invented gravity, and Darwin later discovered the theory of evaluation. There's some more examples in the papers, which I'll let you read about. We have a lot of other ambiguity situations in the materials you can read about in detail, including some cases if you have interest, but they come up in the context of insurance policy exclusions, settlement agreements, energy sales agreements. These are matters that I've handled. There are some other interesting ones in Texas arising from the Texas Tobacco Settlement Agreement, royalty agreements, employer arbitration agreements also, memorandums of understanding. On these ambiguity cases, you need to focus with your attorney on your motion for summary judgment theory very early. That's where ambiguity is determined typically. You do need to educate the judge, particularly if it's a young, inexperienced judge, on the need to determine the ambiguity issue before you actually go down to pick a jury and try the case. Generally, you're going to want to have an early ruling on that unless you really just want to muck up the whole case for some purpose. So don't assume everything is A-OK. It's not necessarily, even if it had been before, it may not be the case at the time. It really does pay sometimes to be a little paranoid. It may be behind you, creeping up on you. You want to check your tail. I know it's difficult times out there. Sometimes it's hard to say no to business. At a minimum, you can really focus on the terms of your contract. Make sure that you minimize or eliminate the time bombs in there. One thing I recommend is having someone do kind of a fresh eye review. Don't have the contract drafted and only looked at and reviewed by people involved in the job or the project. You might even want to get a network attorney to offer a fresh perspective on contract terms. Don't just assume that according to the law of infinite probability, everything will work out all right. Your clothes will magically appear folded in the dryer. You want to avoid the big miss in this case, and in particular, then plan ahead, and then maybe you'll be in a position where you can avoid the big time bomb as opposed to these fellas. A couple of good old Texas boys doing what we call grenade fishing. Thank you very much.